an event like the Africa Law Tech Festival is very important because you want to bring in people from diverse backgrounds in order to be able to solve common problems, right? And the only way you can actually reach effective solutions is if you have different perspectives. So I think events like this are fantastic for people to actually just think out of the usual and come up with solutions that actually work.
The reason why I came all the way from Tanzania is because I'm interested in how law and technology can be merged and how technology can be used to access information. So I thought this would be a good, perfect opportunity to meet people also in the same space and to network and to learn.
I think the Africa Law Tech Festival is an amazing idea. I don't know if in Latin America there is some initiative in this direction. I would love to hear about it because put in connection two worlds that are apparently different, people from law, people from technology. This is an amazing initiative.
We're having intense conversations around learning from each other. And most of all, we're asking ourselves the right type of questions around how we can collaborate creatively together for a common good.
Activities like Law Tech are really important because there needs to be a space for Afro-descendant diaspora to participate, to engage, to invest. We have lots and lots of capital. African Americans alone represent more than $1.2 trillion worth of purchasing power, but it's spread out among small and medium-sized investors, and most of those are African American women like me. And so we want to make sure that we're represented as the tech space and the legal tech space starts to develop in Africa.
I think such events are important because of issues of benchmarking and also interaction. We need to share our challenges, our ideas, and our possible opportunities to collaborate. It's important that we also have these conversations so that we can shape policy, we can shape legislation as well, and at the same time figure out how to interact with other countries, with other stakeholders in the space.
I find the organization of the whole event well informed because it's a process of learning, and I would say for someone who even has never been in this field of law and technology can learn something out of it because it's a step-by-step process and they are very inquisitive, very well sharing the info they know.
This is good because if we are not prepared to step into the future of technology in Africa, we can be left behind.
I've really enjoyed their sessions. They're very interactive, and I think they had a very good choice of panelists and experts.
I am having a really good time at the festival so far. I had great conversations with people. I learned a lot, things that I didn't fully understand before. I met good contacts that I'm definitely going to stay in touch, and I also enjoyed the talks. And I'm really looking forward to the next days.
Thank you very much and welcome to this webinar. My name is Linda Bonyo. I work at the Lawyers Hub, and it's amazing and incredible to have this discussion today, convened by the Law Society of Kenya, Kisumu chapter. I want to welcome you. If you're joining us on the chat, there's about 700, actually 850 people who registered for this particular event, and we want to thank you for signing up to attend. So if you're joining us, there's a chat section which you're able to ask questions on it. If you want to ask a question live at some point, you're going to be able to give you a chance to speak. Just raise up your hand and we'll be able to have you speak. We also have a poll question that we are going to launch as I hand over to Jacqueline to introduce and take it from here. So please participate so that we'll be able to know what exactly you would need and give feedback on this particular webinar. The Lawyers Hub is all about law and technology. We convened the Africa Law Tech Festival that you've just seen excerpts from. So if you need any sort of information, you need to learn about cybersecurity, you can go to our YouTube channel and be able to see all that we do around law and technology. Our website is lawyershub.org that you could visit to also be part of the Lawyers Hub community. So I'd want to just ask if the poll question is ready to launch. So we're just launching a poll now, then hand it over to Jackie. Our question is this: do you think there are adequate health and safety precautions in place to support the physical opening of the courts? Do you think that there are adequate health and safety precautions in place to support the physical opening of the courts? Please go in and say yes, no, or I don't know, and we'll be able to take it up from there. So Jackie, please proceed.
Okay, thank you very much, Linda, and the entire team at Lawyers Hub. Colleagues, good afternoon. Justice Lenola, Dr. Mercy Mwara, Commissioner, Charles Kanjama, good afternoon, and our former president, James Mwamu, good afternoon. So I wish to thank you all for joining us in today's webinar. I see we already 300 participants. This shows the topic for discussion today is something that really matters to not only lawyers, but all Kenyans. So we all understand the role the judiciary has in terms of dispensing justice, and we are again aware of the effects of COVID-19. To the COVID-19, we've had government coming up with regulations that has restricted movement of people, that has also restricted, we also have lockdown in certain cities. All this has affected how justice is dispensed. We are again aware that the judiciary has come up with steps to address or try to just ensure that justice still continues, but we want to find out whether the steps the judiciary has developed actually serves Kenyans when it comes to dispensation of justice. We are aware that the judiciary has fast-tracked plea taking, the review bond, and also prison sentencing. And important for this meeting is the remote hearing. So our today's speakers, we have Honorable Justice Lenola, the Supreme Court judge. In the hierarchy of the court, for most of us, we are aware that it's only the Supreme Court judge that is fully digital. So he will share with us the experiences and the challenges. We want to know if the judiciary, the Supreme Court is digital, so how about other persons who would want to access justice? Are they able to do that? We also have in the panel, Dr. Mercy Deche, who is a commissioner of the Judicial Service Commission, a representative of the LSK, and also the vice chair. We know that the Judicial Service Commission is the governance body of the judiciary. We would want to hear from them what they have done and whether the efforts they have made have actually contributed to dispensation of justice, either negatively or positively. And then lastly, we have Charles Kanjama, a former LSK chairperson, Nairobi branch. We would want him to share more about experiences of lawyers when it comes to remote hearings. And I would invite our chairperson for the LSK Kisumu Chapter Welfare Committee, former President James Agri Mwamu, to do his welcoming remarks, and thereafter invite Justice Lenola to take us through his session. Thank you very much.
Thank you, Jacqueline, and welcome everybody. The Kisumu Chapter Rapid team to just take care of the welfare of advocates and just to assist advocates to navigate through this very difficult period. And one of the things that we have always done is to understand what is going on in the judiciary, in the courts. And I am sure that we are going to have very serious interrogations of some of the things that are happening. I will want to first welcome Justice Isaac Lenola. Justice Isaac Lenola is a judge of the Supreme Court. He has served as a judge of the High Court. He's been the chairperson of the Judges and Magistrates Association. He was a judge at the African Court of Justice. He was also a judge at the UN Residual Court for Sierra Leone. And perhaps I just want the judge to touch on how the Supreme Court is navigating through the challenges posed by COVID-19 and what kind of sacrifices and flexibility that will be expected from both the judicial officers and the judge and the lawyers during this particular period, and what will be the way forward if this particular situation exists. And the judge, just before you sign off, You have had an illustrious career from St. Mary's Maralal Nursery School to Maralal Primary School to Baragoi Primary School, then Alliance Boys, University of Nairobi, became an advocate of the High Court of Kenya. You become then you became a judge, served in CKRC, East African Court of Justice. In our country, where people believe that somebody must hold your hand to take you to where you are, what particular lessons would young lawyers and young judicial officers get from your eyes? Is hard work a virtue of hard work now dead? As you sign off your remarks, perhaps you touch on that in terms of mentorship. I'm sure that there are people who want to hear from you that your long journey has not been through luck, but there are certain principles that you have lived. Welcome, Justice Isaac Lenola, and take it from there.
Thank you very much, James Agri, and thank you for the invitation to join this fantastic session. I think, first of all, I'm excited that as we struggle with technology, a group of lawyers were way ahead of us in terms of thinking through the need for technology to lead any conversation around access to justice and justice generally. Before I answer the substantive question that you asked me, let me lay down a contextual basis for what I will say shortly. Number one, I think for us to talk about technology and access to justice in the period we are in, we must remind ourselves of the principles of justice that any court, any judiciary must abide by if we are to do justice to the people that we serve. And therefore, let us remind ourselves that we have a number of principles that are important. Number one, substantive justice. Are there fair decisions from our courts? Number two, procedural justice. Do we have fair processes? And this is the question we're addressing now. As we go into technology, is there fairness in it? Do litigants feel that there's fairness? Open justice, transparency around the systems that we deploy. Distributive justice. Is the justice available to all? I mean, is this technology we're talking about available to all? Or is it limited to a few? And what is the consequence of that situation? Number five, we must have proportionate justice, a balance around appropriation of justice to everyone. Number six, enforceable justice. Are litigants who succeed able to enforce their judgments within time and by what means? And number seven, sustainable justice. How do we ensure that all the processes that we put in place are sustainable and the justice result is also sustainable? At this point, I think I must also say that we must start to realize that online dispute resolution must find space together with ADR, so that even as we talk about inability to access courts physically, we should talk about mediation, we should talk about arbitration as ways of easing the pressure on the courts. And I think this is the moment that ODR, online dispute resolution, and ADR must find common space. To the question I was asked about the Supreme Court, I think we must appreciate that the Supreme Court is a unique court in many respects. Number one, it's a smaller court. Number two, it deals smaller number of cases. But more importantly, the Supreme Court in the Kenyan situation has had more access to technology than other courts long before the pandemic hit us. So that, for example, in the rules of the court, which were published, and I wish to inform some of the lawyers who may not know that we have new rules. On the 14th of February 2020, just before the pandemic hit us, we published new rules of the Supreme Court. And in those rules, Rule 3.3 provides as follows: the court may use appropriate technology in its proceedings and operations. That's a very wide mandate given to the court in terms of how it uses technology for its operations. Number two, rule number 12 states as follows: pleadings and any other document filed in the court shall be in both printed and electronic form, so that the Supreme Court, before the pandemic hit us, had provided for filing of pleadings, even in electronic forms, although in the second rule, hard copy still prevail. Rule 2 defines electronic media to be any type of device that stores and allows distribution or use of electronic information. So that by 14th of February, the Supreme Court had prepared itself for the future, not for the pandemic, in terms of how it can manage its proceedings through the use of technology. The other issue we must address about the Supreme Court is that the Supreme Court is, in a sense, then, in a more advantageous position. The Supreme Court does not have to hear witnesses. It doesn't have to get screens at committee or the prisons. It can, on submissions alone, make a decision. Already the rules of the court allow the court, in fact, it is a rule that the court will not hear applications. It will read submissions and make rulings based on those submissions and transmit those rulings electronically. So that those who participated in the last 13 rulings that the court delivered will have noticed that we did not have to call a judge to read them in the usual manner. We merely ask for your email addresses and we send those email addresses to you, and therefore we didn't have the connection, human physical connection that is now affecting the other courts. We must also understand that because the Supreme Court has fewer cases, has fewer advocates appearing before it daily, it is easier for the Supreme Court to manage its diary and its cause list. Minutes before I started this meeting, I received an email from the Deputy Registrar informing me of the cause list for the coming days for the Supreme Court. I am in my house so that advocates can receive the same cause list in the same manner I'm receiving it. And so the Supreme Court is a lot more advantageous in that respect. We must also remember the Supreme Court has very few self-representing litigants, so that we do not have the struggle of asking ourselves what happens to a guy in Siaya who has an appeal before the Supreme Court and who must then be heard virtually. In the last hearings we had no party that was not represented. It was easier then to get advocates to appear. Even where advocates had difficulties appearing before us because they did not have technology in their offices or in their houses, we had in the court a laptop, a clerk, and a particular advocate spent all his morning in the court making his submissions with the technology provided by the court, so that we don't have the difficulty which we are seeing in the High Court and other courts where self-representing litigants are struggling to get access to the court. We have also had the advantage, being a smaller court, having fewer judges, acceptability of technology by all judges and all advocates before the court has not been difficult for us. And to that extent, therefore, the Supreme Court was lucky that when we began, and I'll speak to the issue shortly, when we tested technology, initially we tested the Zoom. You all know what happened in South Africa when the system was hacked and the courts were in embarrassment. We understood the challenges of security of the system. We are now using as a court Microsoft Teams. We have all been trained in it. We all have accessibility. And all the advocates who are appearing before the court have also had little difficulty, say what I'm going to say shortly, in terms of use of technology. So that to that extent, the Supreme Court has had a better time than other courts. What are the difficulties that the Supreme Court has faced in the last couple of weeks in terms of the use of technology? Number one, we at one point considered sitting in court, but having a big screen in the library or in the court where then advocates can log in as the hearing is conducted by the judges while sitting in court. You have all seen, you've all come to the Supreme Court. That is a 1933 court. It is very small. It was never envisaged that 7 judges will sit in that court. The extensions made would never have allowed for the physical connectivity of the judges, so that we've had a problem around that courtroom. Already, even as 7 judges, we are squeezed. it is impossible with the 1 meter, 1.5 meters distance per person for us to have access to the court. And therefore, although the court does not have as much traffic as Milimani Law Courts, which has, I'm told, averagely 5,000 persons per day, even then, it has been very difficult for us to have any sittings, any hearings in the court. So we've had to conduct hearings from our houses. Number two, I think we must. I think it was Jacqueline who spoke about the Ministry of Health guidelines, and I think the question you're going to answer in the poll is whether the guidelines are sufficient. I think we must appreciate that those guidelines are based on certain professional decisions by the Ministry of Health. So that if they say persons over 55 or 56 should not work in offices, they should work at home, the Supreme Court has 6 judges, 4 of whom are over 60 years old. And that fact alone would impact individuals in whether they are comfortable sitting in open court with others, whether they are younger or older, and other people outside that bracket who may appear in their courts. Number 3, connectivity remains a problem. Because our country has issues generally of connectivity, we too have struggled with it. A lot of you may know that the Supreme Court building is made of literally rock. And for some very strange reason, I guess, getting internet connectivity in the building itself has been a problem. But secondly, until and unless we have such connectivity where we work, we still have the problems of, my Lord, can you hear me? My brother, can you hear me? Last week actually, we had a case involving 2 lawyers from CIA, and they were making submissions from the office. And we had difficulties because what they said was that CIA has problems if it rains and so on. So connectivity remains a problem for the court. It remains a problem for the lawyers. I spoke earlier about the need to have appropriate applications. And I said we have settled on Microsoft Teams. It is working for us. Facebook and Twitter have only remained information platforms for sharing information. What then do I project as the need for us? What should be done looking to the future? Number 1, I've spoken to my colleagues across the world. I have friends in New Zealand, in the UK, in the US, in Italy, in Greece, in Netherlands, in Belgium. Where we are as a country and as a judiciary is exactly where they are. The systems they have employed in conducting their proceedings are the same proceedings systems we are using. So we are not out of the loop in terms of other countries. What is my view about what we need to go into the future? Number 1, I think we need firm leadership in terms of the need to embrace technology. The CJ, the LSK, the NCAJ must work together and speak with a common voice as to where we need to go in terms of technology. Number 2, we must have a clear strategy as to how we must ensure technology works for us. We need incremental transformation, not a big bang sort of thing. And we must carry everybody along. All users must be carried along so that no one is left behind. Sometimes it's easy for the judiciary to run. The AG's office is not with us. The LSK may run. The DPP's office is not with us. Each user must be carried along. And lastly, we must have expertise and skill which can ensure that the technology is working for us. Those are my thoughts around the question that you asked me, James Agri-Mwamu. My story, as I conclude, it is true indeed that I've not had it easy. I've struggled like everyone else. I doubt I can say categorically I've not had any godfather who has held my hand. My godfather probably is my God. But I think 3 things that I must say. Number 1, there is no substitute for hard work. I'm a very early riser. I work extremely hard and I take my work seriously. There is no substitute for focus and resilience. If you're focused, if you're not resilient in getting what you want to get, you'll remain at the bottom of the rank. Number 3, every individual ought to have a personal strategic plan. If you don't have a personal strategic plan, then you're floating through life. I have had one, I live by it, I abide by it, I follow it, I push it, and I review it every so often, as I may do so very, very shortly. I thank you very much. James again. Mom.
Thank you. Thank you.
All right.
Okay,
thank you.
Thank you. Thank you very much, Justice Lenola, for a very insightful discussion. What we've learned is that, yes, the Supreme Court is doing well, but you are at a very advantageous position compared to other courts. And what we need to do for the future, that is, we need to embrace technology, but at the same time, ensure that we carry all users. So our next speaker is Dr. Mercy Mwara, who is
Okay. Can you hear us, Jackie? You went off a beat. Okay. So as we find Jackie, we just want to launch the poll results. If you can see the poll results from the question we asked you, do you think there are adequate health and safety precautions in place to support the physical reopening of courts? And the results are out. If you could just play the poll results. A majority of you think that we do not have adequate health and safety precautions. That's 61%. And the ones who think we should reopen the courts, that's 23%. And 16% say, I don't know. And I like what Jackie had pointed out to what's happening in Uganda. Uganda just yesterday released, what needs to happen before courts are opened. They gave physical restrictions. And also how many people should be in court. So I think we'll be sharing that on the chat as well if you haven't come across that document. But I'll bring this back to Jackie to proceed, and also the panelists to also, I think, weigh in later on the impact of this particular poll. What do you think about it as you handle the other questions? Jackie.
Okay, thank you very much, Linda. Quite interesting observations from the participants on the 61%. We are not there yet. So just a point of clarification, the example I was citing was for England and Wales. And if you're aware, 2 weeks ago, the Judiciary started opening up jury trials within the Ministry of Health protocols. And while doing so, the Chief Justice made this observation, that it is important that the administration of justice continues to function whenever it is possible in an environment which is consistent with the safety of all those involved. And then still in the UK, there is a judge in the Technology and Construction Court, I'll type the case citation there, who had this observation to make on when hearing should be done remotely. One is that there has to be regard must be focused on the importance of continuing and administration of justice. And then number 2, to the extent to which disputes can be resolved fairly and remotely. So I will now take the question to Commissioner Mercy Mwara on whether the judiciary has the capacity, and when I'm talking about capacity, is both human and equipment to fully implement remote hearing. We've heard what the Supreme Court has been able to do, but we'd also want to hear what are the challenges or effective processes that the judiciary has put in place for the very low courts, especially the magistrate courts in far-flung areas. And then number 2 is just again picking up from what Justice Lenola had mentioned on distributive justice. We have seen on news on social media where you find certain courts operating physically, and there are those who have just restricted the opening of the court and just allowing remote hearing. So is it possible that the judiciary can then ensure dispensation of justice is uniform across the country? And then lastly, there is a high likelihood you're going to have backlog of cases after this pandemic, though we don't even know whether this pandemic is going to end anytime soon. So what plans has the judiciary put in place to ensure that we address the existing backlog, at the same time have means of addressing the future backlog we expect to have after the pandemic? Thank you.
Thank you very much, Jackie, and all the panelists and those who are following us. I just want to start by putting again everything into context. To say that as we discuss access to justice, we know that there have been barriers even before COVID. And to me now, COVID presents another barrier to access to justice. It joins the list. But whereas we know what to do with the other barriers, this particular one has been very unique because first and foremost, it came in unannounced. There's still so much mystery about it. There is the issue of we are supposed to treat it abnormally so that it treats us normally. And there's a lot of fear around it. So it is amidst all this new phenomenon that the downscaling happened, or where we are now. And I find this conversation extremely useful because, as you have read from the UK, that article you have read, or the statement you have read from the UK courts, there is this whole idea of having to balance between safety and administration of justice. And it is such conversations that when we hold them constantly, because there is a gap between safety and administration of justice, the more we discuss and talk about it and engage, the more we are going to narrow the gap. Now, I will go straight to the issues that you have raised, because what has been happening is that since the 16th of March, the people you saw standing on those staircases that are more famous for us standing there to say there's no money, but the group that was standing there at that time was not JSC, it was NCAJ, and that was strategic because the people who have been running with the whole issue of access to justice has been NCAJ, which is more representative because it represents a wider spectrum of players in the justice system, and LSK is also represented there. And I found wisdom in the CJ choosing that platform or to respond to the COVID pandemic. But that doesn't mean that the JSC has been just watching. The Commission has continued to play its oversight role, even on the decisions that have been made that impact on the administration of justice, because that's the constitutional duty or mandate of the Commission. What has, with regard to the capacity, ICT capacity of the judiciary, of course, seeing that this was something that was not planned, I equate it to the man who swam across a pond. A story is told of the man who swam across the pond, and when he reached the other end, he was being asked, how did you make it? And his question was, who pushed me? So even in the judiciary, we are in that situation of who pushed me. We were pushed by COVID into the deep end of embracing ICT. And I don't say this with much pride because previously we have had situations where the judiciary has had several false starts with regard to embracing ICT. But this time there was no option but to at least get it right, at least to a certain extent. So the capacity, but ICT is by its very nature a very heavy investment. And what has happened is that this response, ICT response that you are seeing during COVID, has been with very minimal resources. You remember that the directions that were given to redirect funds that were for other uses towards managing COVID. And Judiciary had available a paltry 50 million, I'll call it paltry because this was to be used across the country to support ICT. And it was from almost close to 0.0. So that is what has been used. But I am happy to say that going forward, because we are getting into a new financial year, there has been the budget that has been prepared by the Judiciary and the one that we have engaged Parliament on, we as JSC, is very heavy on the ICT component. And I'm glad to say that there has been a lot of support from the various parliamentary committees with regard to making sure that that budget is honored, at least by the executive. But having said that, we are still not out of the woods as far as ICT is concerned. I have seen some of the comments where people are talking, decrying the whole issue of filing through emails. And since we are here to demystify issues, let me demystify that when you file a document or an application or a suit through email, at least in other courts other than the commercial court and I suppose Supreme Court, it is not electronic filing. It is not the e-filing that we know of. What happens is that this filing by email is then supported by a lot of human intervention at the background. So it is only the filing, the email that is electronic. The rest of the interventions are very human, and right up to the fee assessment and getting back and forth. And the volume of emails that come are also very, very high. In Milimani Commercial, for instance, we have noticed that there is one email every minute. That is how it is. So unless we get the whole component of e-filing right, and by e-filing, I mean the kind that has been piloted in Milimani Commercial, we will continue to experience these problems that we are getting. But I'm glad to say that the two hindrances that had come between e-filing and delivery of services have been sorted. The first one was storage, because we needed, I bet that is when we talk about servers, we did not have sufficient storage and we did not have capacity to procure sufficient storage, but the Judiciary now is at advanced stages of procuring that storage. And over and above that, there was a problem of assessing court fees through the e-system, and that has also been worked on. Soon we will now move, or the Judiciary will be able to move away from that apparent filing through email, which is not really electronic but human supported, to proper e-filing system. The other issue I want to say is that the Judiciary has moved away from grumbling all the time to finding solutions and being innovative, at least as far as ICT is concerned. And one of the ways that this has happened is through partnership with the ICT Ministry. Judge Lenola has talked about Teams. We've now moved from Zoom to Teams. And these kind of platforms require licenses that are not that are rather costly. And what has happened with these Teams, it has been acquired through the support of ICT, meaning that the license was ICT Ministry, meaning that the license has been acquired by the Judiciary, for the Judiciary by the ICT Ministry. Over and above that, the Judiciary has been very thin on manpower. When it comes to ICT manpower, I think we have realized that there are very few ICT officers on the ground, and what the ICT Ministry has done is to release about 70 officers to assist with ICT on the ground. Other than that, I just need to say that although it has started as a stopgap measure, the Judiciary is hopeful that, not hopeful, has planned that this should continue post-COVID, so that the gains that are there as far as ICT is concerned should be carried on post-COVID, such that we can have instances of cases for maybe mentions and applications, those kind of matters that do not require face-to-face hearing to be heard through the platform, the existing platforms that have been carved out during this time. Of course, there is the issue and the concern of a majority of Kenyans not having access to both the soft and the hardware that is required in the ICT. And Judge Lenola was talking about the need to facilitate that. And I can say that in the Court of Appeal, for instance, the Court of Appeal is one of the courts that's doing very well. I will not say better than the Supreme Court because Judge Lenola is here, but it's doing very, very well. Of course, for obvious reasons that they also have very few people who are represented. But what the registrar of that court has done together with his team is to set aside court number 3 in the Supreme Court as a center for the unrepresented people. And so those people who are unrepresented are still able to, they are called on phone and they are able to come to the court premises and proceed with the matters online using the gadgets of the judiciary and the Wi-Fi of the judiciary. And so far we have had about 15 of these matters finalized that way. And it is hoped that these will be rolled out to the High Court, where we are looking at having cyber kiosks in all the High Courts for those people who are not able to access this technology. But that is something that will require a lot of partnership from many stakeholders. But let me say this, other than the technology, ICT, there are plans to work on return to normalcy. That is upscaling. Maybe we'll never return to normalcy, but plans are at an advanced stage to upscale the courts. So maybe we'll even do it better than Uganda or any other jurisdiction. And this is why. Remember, what preceded this plan to return to normalcy was an engagement with the experts from the Ministry of Health. And they were not engaged so that they dictate to the judiciary whether or not they were to return to normalcy. They were engaged because they are the people who have the knowledge and the expertise. The judiciary does not have experts on matters of public health. So what has happened is that there were inspections which were done in courts across the country, and reports, not a report, reports have been released, not a single report. So each court station that was evaluated, there are reports which are trickling in. By yesterday, there were about 30 of them, and more are coming in. And what the judiciary has done, the judiciary management has done with those reports is send them to the heads of station with a requirement that the heads of station do have a sitting with, first and foremost, with the CUCs, the court users committees, and then with the bar bench in order to craft out a mode of returning back to physical face-to-face administration of justice. And this has been found to be very, very critical instead of a one-size-fits-all, because the circumstances are very different. I'm sure most of you are pitying me because I am in Mombasa. Circumstances are different here in Mombasa, but there are other places where things are totally different. So that is how it's going to be rolled out. And the heads of stations have 14 days within which, after meeting the 14 days to meet the court users and the bar benches in order for them to craft out how to go about the way forward, and thereafter now revert to the CRJ in case they need any help. And we have already anticipated the kind of help that will be called for. It will be in the nature of those stickers that you find on sitting spaces and standing spaces. It will be in form of masks. There are also dispensers for sanitizing, and in some of the courts, like in Milimani, we will have no choice but to have these booths for spraying, for sanitizing. So that is already being procured, and we are looking forward to a physical return to rendering services or upscaling, substantial upscaling. And there is a committee of, or a think tank of registrars who have been tasked with looking to at certain issues, for instance, backlog, to advise on how are we going to deal with backlog. And because of course backlog is accumulating, there is also the issue of matters that were listed for hearing March, April, May, and I hope not June. How are they going to be prioritized in when it comes to when we get back to work? And then there is we are anticipating probably there might be a crowding once physical reopening is announced. So how do we anticipate that, and how should the crowds be controlled? And then there is also need, at the same time, we have to sustain the use of technology. It's not going to be dropped. And then there's also they are also looking into this pandemic being endemic, for us being with it for a very, very long time. And so that is, those are the things they are going to look at. So in the coming weeks, in the coming maybe 1 week or two, we should expect some return to work. And I understand when people are anxious about the return to work, as I can see from this poll, there are those, I am of the view that some work can still be done face-to-face, even with these guidelines. But I do understand, because some of us are not young, others have pre-existing conditions. But I believe it is in engaging at the local levels that we will make progress, both with regard to the ICT and enhancement and the return to normalcy formula. I think I have answered all the questions, Jackie. There is the issue of ensuring that there's uniformity in rendering services. Jackie, do you know that can never be, because even before COVID, there's a differentiation in the way judicial officers render services. There are some who are creative. A judge will forgive me for saying that. Others are not too creative, but that is where we are. So maybe the best thing is to streamline those who have best practices, to institutionalize those best practices, as we urge or nudge the ones who are not so innovative to catch up. But we will always expect those differentiations, because there are those who don't need to wait for Ministry of Health to tell them, stay 2 meters apart, observe 2 meters. There are those who will not do that, but there are those who, again, we will wait for that circular. And this was there even before COVID. Thank you, Jackie.
Okay, thank you very much, Commissioner Mercy. I know majority of Kenyans, including lawyers, are happy to note that the judiciary is thinking of upscaling its services and reaching out to the CUC's Babbage Committee to find out the best ways of going back to work under the return to work formula guided by the Ministry of Health protocol. Also, we wish to thank you for being truthful and just confirming that, yes, there are gaps in the judiciary, and you no longer want to blame anyone, but just trying to find ways within the judiciary on how you can promote justice. Your work with the ICT ministry is well noted, and capacity, ICT capacity for judicial officers and staff. So I'll allow Byron to take over the session. Hello. Byron?
Thank you, Jackie. informative session from the Kenya, and indeed we are grateful for our appearance today at this webinar. I think she touched on one thing, and also
There's a challenge with your sound, Byron. There's a challenge with your sound, Byron. If you could just sort of fix it again. There are two devices I think you're joining in from that are giving feedback. Okay, Jackie?
Okay, our next panelist is Charles Kanjama. Byron, can you proceed? Or there is a lot of noise from the background.
Okay, Byron, the issue is on your side, so maybe I'll just ask Jackie to proceed as we try to fix it on the chat.
Okay, thank you. Senior Charles Kanjama, having heard what Justice Lenola and principles of justice and the procedural justice, proportionate justice, and possible justice, as a lawyer who also sat in one of NCAJ's meeting, what is your take in terms of what the judiciary has done in ensuring justice is seen to be done? The wheels of justice keep moving. So kindly give us your thoughts, your experiences on electronic justice and the challenges there too.
Okay, thank you, Jacqueline.
Sorry, Charles, and your thoughts on what Commissioner Mora has mentioned, that very soon you're going to have directions on upscaling of services.
Okay, once again, thank you, Jacqueline, and good afternoon to the panelists and all the attendants. I think I'm delighted to be here. This is an extremely important topic. I have been, until now, the chair of LSK Nairobi branch. I'm handing over end of next week. And in Nairobi, we've been involved in the pilot project of e-filing of the High Court Commercial Division. We've had several meetings, Bar Bench Committee, Court Users Committee, as well as meetings with the leadership team in the High Court on this pilot program and its various challenges. I've also been the chair of the caucus of LSK branch chairs, and we've met the Chief Justice twice in the last 2 weeks, among other things, to discuss the challenges that lawyers are facing with the current COVID pandemic. I also know that the LSK Council is having a meeting with the Chief Justice. Either they had one today or they're having one in a very short period of time. It is also true that I was nominated to attend the meetings of the Technical Committee of the National Council of Administration of Justice, and I also did accompany President Nelson Havi of LSK in one meeting of the main NCAJ to discuss the questions touching on technology and COVID. And the first thing I would like to say from all this experience is that the process of digitization in the judiciary is one that has taken many years. It is long overdue, but finally it is making progress. When I was a young lawyer, when I had just become a lawyer at the turn of the millennium, I remember there was a project to digitize court documents. And for some period of time at Milimani commercial courts, court files were not available. After 3 months of digitization, the project just ended. We don't know what happened to those documents. So it is the digitization of the judiciary plan is at least 20 years old. But this last cycle has followed a trajectory that we have welcomed as LSK. We've been invited to participate, at least at Nairobi branch of LSK. There have been a lot of meetings. The key driver of this project is IDLO, who have been the main partner of the judiciary in this project. We have discussed several issues, with the key question being, when will we reach the point that we can liberate judges and magistrates. In fact, the word is liberate. Liberate judges and magistrates from having to record by hand proceedings in court. This is something that in some countries they did decades ago. So it's like something of the 20th century, and we have been struggling with it in the 21st century. So that has been like the holy grail of digitization. But in addition to that one, we have been discussing the question of e-filing. How can we get documents filed electronically instead of physically? And of course, there have been numerous challenges like electronic signatures, getting email addresses of lawyers. How do we get lawyers to have their information in a database that is accessible by the judiciary? Also for e-service. So we've been trying to deal with all those challenges. What I can say is that the pilot project has lasted for almost a year, and it was high time that we digitize. So we are welcoming the plans that the judiciary has shared with us, that in the short term, in the next few weeks, they are going to now unroll that pilot project to all the courts in Nairobi, and then in phases to courts in other parts of the country. What I would say though, after talking about the digitization process in general, is that the current approach, which is like short term during the coronavirus pandemic, to echo what Dr. Mercy Deche has said, is not really the digitization that we are looking for in the long term. It is kind of like a crisis strategy where people are sending documents through email. It is not clear whether the physical documents will have to be filed later. We are still serving through physical means, sometimes through email. So there's a lot of confusion, but it is a crisis solution that is meant to last only in the short term. My personal experience as a practicing lawyer is that I have used Zoom, I've used Teams, Microsoft Teams, I've used Skype, and even for one court attendance in Mombasa, I used email. You can imagine we did a mention by email where each of us was sending email back to the judge and to one another. And after 2 hours, the judge came up with some direction. So I have seen certain challenges with technology, connectivity, access to the technology means, and of course, the biggest challenge with the current approach during the coronavirus situation is that we are not able to have hearings. So the cause list, and that is what LSK has been pushing, the cause list that was suspended on 16th of March, in many courts has not yet been revived. And even when I had a Skype hearing in the commercial division, and I had a hearing and I asked the judge, can we proceed? Can the witness testify on Skype? The judge was reluctant to do it and said, I will adjourn the matter to 30th of June. And so I asked her to then give directions that if by 30th of June, physical hearings have not started, we take the evidence via Skype. So that even the courts that have begun going through the cause list, like the High Court Commercial Division in Nairobi, they are not yet at the stage where viva voce evidence is being taken. So those are some of the challenges that we have been facing. LSK's position, which has been the position of the leadership of LSK in the council, in the branch, in the branches, the branch chairs, and even our representatives in JSC, I hope, Mercy, I'm not misquoting you, is that we want more upscaling of judicial services, and that we need sooner rather than later to reach the point where some physical hearings can take place. And we feel that the rest of the country, people in other sectors, are resuming with social distancing their normal businesses, with social distancing. And we've been asking, why can't we also have some physical hearings? To conclude on the question you asked, I just want to say that one recommendation I give in several forums when we are engaging with the judiciary is that we have to be alive to the fact that going forward, there will be largely three methods of proceeding with cases. The first is the electronic method without oral hearing. The second is electronic method with oral hearing. And the third is physical attendance in court. So I think Judge Lenola referred to how the Supreme Court deals with applications. They normally don't have oral hearing. So in such a case, it's easy to do electronic method without oral hearing. In the Court of Appeal, there are also applications also in the court where parties do not need to highlight. And in those cases, electronic proceeding is possible without oral hearing. Then you have the second approach, which is electronic, but with oral hearing, either via Zoom or Skype, Microsoft Teams, or another platform, like the way we are having this webinar. And I think it is high time we have more of those proceedings. Right now, we have some applications and mentions taking place through this means, but hearings of witnesses only very seldom so far. So we need to find protocol for dealing with this. And then finally, we have physical hearings. And we will need to have clear arrangements for how many parties can be in court at one point in time. How do we ensure that, for example, not all the matters are handled through the cause list at 9 o'clock? You may have a cause list of 20 or 30 matters. And this is what tends to cause crowding in the court. So we'll need to have strategies where maybe the first 5 matters are handled from 9 to 10. Then at 10 o'clock, there are some additional matters and so on. Allow me to say that I therefore would like to persuade the attendants listening in that it is high time we start the process of reopening of the courts. Health and safety measures are being put in place as we speak. And unless we start, we will not have all the health and safety measures in place.
Senior Kanjama, for your insight, your experience on what you have been able to go through on matters remote justice and the work that you have done with NCAJ and a member of, as a chair of the caucus of LSK branch chairs. We really appreciate. One thing that I took note is that even when we are discussing about resuming, what was the word? Resuming court, physical court sessions, how do we then try to identify areas that would go 100% remote and others that would be physical and remote? So I would then ask Linda to read out some questions that have been sent out on her portal. Byron, if you have any other questions that have been sent directly to you, kindly share with the panelists and members of the participants who've joined us. Thank you.
Okay. I'm going to just ask several questions. We received some emails as well before this particular event, so I'm going to read out some of them. But meanwhile, we are launching a poll because the next question is going to be about platforms. And we are asking, what video conferencing platform have you used and prefer over the rest? And this is emanating from the discussion from Justice Lenola and also from Senior Charles Kanjama. What video conferencing platform have you used and prefer over the rest? We have Microsoft Teams, Zoom, Google Meet, we have Jitsi, and also we have Kenyan company called Gumzo. So we just picked a few just to find out what exactly you're using. And that will lead us to the question that has been asked about data protection and also privacy. There have been issues around privacy that people are asking, how sure is Judiciary that they are safe on the platforms that they are using? But also from the human rights point of view and people who are watching Brief, the question has been, are you locking out people who are watching Brief, organizations that are following up on cases or writing or researching on these particular issues? How do you ensure that judges do not just send out links to only advocates, but locks out the public from engaging on court matters that are actually public and not maybe issues around children that may be sensitive and family issues in this particular case. So I'd want to direct that to Dr. Mercy and also Justice Lenola from the experience that they have shared. I think we could go that way, Jackie.
Okay, so do you have questions? If you could maybe summarize, you don't have to read them word for word. I've been able to get a few from Wilberforce. He has asked that courts need to open, provided they do that within the Ministry of Health protocols, because other service providers are doing that. I think that Commissioner Mercy was able to respond. And then to Justice Lenola, a question has been put forth on whether online platforms go against the tenets of open justice, because people are not able to know what is happening behind the screens. That's the computer and all other gadgets related to ICT. Janet Patricia has given a proposal, which I think Commissioner Deche, you can respond to that, on how the judiciary can reach out to stakeholders to ensure that we have hubs that can provide connectivity for persons who cannot access. And the example she cited is the Law Society can do that, NGOs, and I think this one she's focusing more on prisons. We have seen cases where prison department is not able to join in court session because of few gadgets. Yeah, I think that will be it from my end. Linda and Byron, if you have any questions so that they can respond to the questions at a go.
Okay. Byron, you wanna go first? Okay. All right.
Hi, Linda. Hello.
Byron, just stop the video so that you can continue.
Okay, Linda, can you proceed? Byron?
Okay. I'm so sorry.
Maybe you unmute Byron, eh? He's having challenges.
Okay.
Mute Byron. I think he's having challenges.
Okay. Apologies for that. We talk about the gods of the internet who decide when you should speak or not. So we hope that we get this done to the end. So sorry, Byron, for that. We had a question from Mary Muigai, who sent an email and asked that it takes 2 years for a vaccine to be in supply. Will courts close for the same periods to secure safety of the seniors who are said to be vulnerable? If so, does the current top administration of the judiciary, particularly the Chief Justice and the Registrar, still consider themselves fit to continue in office? Is there any prick of conscience of judicial officers when they receive pay from the taxpayer after offering little or no service? We also have Henry Nyakweba, who asks, what is the e-education of both the bench and the bar to ensure that the electronic filing succeeds? Are both the bench and the bar fully equipped? And what do we do with Wanjiko? Is anybody training Wanjiko, and who will meet the attendant costs? Then we also have Elias Mugendi, based in Embu County, who says that COVID has disrupted his case and he would want to apply for review, but he's unable to get in touch with the judge. So what about the people who self-represent? Are we getting in touch with them directly and updating them on their cases? Finally, I think the question about being tech agnostic, where the judiciary does not choose one particular technology and sticks to it. How do you move, for example, from Teams to Zoom or to Hangout or to Jitsi? Because your data sometimes is locked in there. The negotiation did not envision a point where the judiciary needs to move to another platform. How do we ensure that there's no vendor lock-in and that we still can access this particular information? Some of the information is stored on the cloud. What's the judiciary doing about this? And also finally around having procurement from the ICT ministry. I would want to really find out, what was the Law Society involved? Were the lawyers involved in this particular procurement process in getting to settle for Microsoft Teams as well? And I will point to the poll just before I proceed. The poll indicates that a majority of the lawyers on this particular chart are using Zoom. 69% say they use Zoom and prefer it over the rest. 25% are using Microsoft Teams. 5% are on Google Meet. Nobody's using Jitsi. I'm using Jitsi. It's been voted the most secure privacy platform. And Gumzo is a Kenyan one that most of us have not tried out. So I think over to you, Jackie, and the panelists.
Okay, thank you, Linda. Just maybe two more questions to Commissioner Mercy. One is self-representing clients in custody. They'll not be able to participate in the CUC or the bar bench committees. So what is going to happen? And a key point is the case, the majority of them have pending revision after the Murwatetu's decision before the Supreme Court. And then the other question is on children matters. How can they be expedited during this period? Thank you. Linda, you had said participants can as well raise their hands. Has anyone raised their hand for a question? Yes. So that we just take the questions at a go.
Okay, we have Michael Wiso who raised up his hand. Michael, can you go ahead and ask your question? Beatrice Munialo, you can prepare as well as Wilberforce Akelo. So Michael? Michael, you can proceed. Okay. Beatrice, you ready? Okay. Jacqueline Manani?
Yeah.
Jacqueline Manani, you can proceed to ask your question.
Yes, good afternoon, everyone. Thank you, Justice Lenola, Dr. Mdeche, and Charles for your presentations. I have a question to Dr. Mdeche. Yesterday, I watched an open air session in which I think it was a German who had been charged with defilement. And I was really shocked. It was open air, there was no social distancing at all. And so I'm wondering, we are now thinking of reopening courts, and Dr. Mercy has indicated what the judiciary is doing about ensuring health and safety measures. But I'm wondering, it's one thing to have it on paper, it's another thing to actually ensure that it is physically being done. Because I watched in shock as I think there was an interpreter standing next to the German, right next to him. Both of them had masks which were under their chins, and they were speaking facing each other. Behind the seats, people were sitting just behind them, and there was no social distancing. And the magistrate was continuing with the session, and it's like not noticing what's going on. So I'm wondering how we will ensure that not only are the health and safety measures on paper, but they're actually being practiced. Thank you.
All right, thank you, Jacqueline Manani. Beatrice Munialo is ready to proceed. Beatrice? Beatrice? Okay. Maria Mbeneka, you can ask your question.
Thank you very much. Thank you, Linda, and the panelists. My question is to Commissioner Deche. Could you please tell us whether the transcription or transcribing of court proceedings is also a priority now that we are adopting technology, even post-COVID when the courts reopen? And how far are we with the integration of the court management system between the judiciary, the ODPP, the prisons department, and how soon can we see this happening? Because I know for a fact that it was part of the agenda of the court management integration system that has been undertaken through Justice Getambu's committee. Thank you.
Okay. Thank you very much, Maria. Beatrice is having issues with her audio, but her question is, can the digitization process be extended to ODPP and the NPS to provide safe plea taking? We'll take the final question from Richard Onsongo. Richard, you can proceed to ask your question. Richard, can you hear us?
Good afternoon.
Okay.
Good afternoon.
Yes, Richard, we can hear you.
Thank you. It is now becoming apparent internationally that COVID is here to stay. COVID-19 is not about to wind up. It's not a passing cloud. And the earlier we accepted that, the better. And at the end of the day, with or without the current advisories on social distancing, masks, and washing hands, finally, at the end of the day, some of us, and I'm not saying me specifically, but some of us will have to die as victims of COVID-19. Now, all these that measures the judiciary is taking, what are you aiming at? Are you aiming at reducing deaths or avoiding deaths? That's number one. Number two, does the judiciary have medical experts who have an international outlook on the phenomenon, the COVID-19 phenomenon, who would advise you that at one point in time, we will have less infections or more infections or a second wave of bigger infections or something? Do you have experts who advise you? Lastly, what is your take now that there are discoveries or there are medical reports coming out that COVID-19 is not a question of it affecting, is not a virus affecting your lungs, but it's some kind of thrombosis. I mean, whether you get it, if you're going to die from it, depends on the medical, medicine you're going to be put on or the treatment you're going to receive. Does the judiciary take into account the fact that you can get unwell and then get well and proceed with practice?
Thank you very much, Richard Nsongo. And finally, Daisy Kurgat, and then I'll take it back to Jackie. Daisy Kurgat. Daisy, you can proceed. Please unmute, Daisy. Okay, Daisy, you have to unmute on your end. Kindly accept. Okay, we are unable to get Daisy. So I think we can proceed, Jackie.
Okay, thank you very much, Linda, and participants for the very informative questions. I would ask that Justice Lenola starts with responding to the questions that have been advanced, and the only question so far is on the open platform, whether they go against the tenets of open justice. And if, Judge, you have any other input from what the discussions that other panelists have given, would gladly want to hear from you. Thank you.
Thank you very much, Jacqueline, and thank you, everyone. Thank you, Dr. Deche. Thank you, Charles Kanjama, for your presentations. I think this has been very informative, even for me, sitting from where I sit. And thank you for the questions and the comments. I've been reading the comments as we were proceeding. They're very useful. On the, let me begin with the question of security. I think one of the issues that we must be careful about in the use of any technology is security, more so where the courts are involved. So that, for example, we in the Supreme Court sometimes exchange drafts using secure emails. Is that possible in other courts? And how secure is ours, for example? Number two, I think Kanjama raised the question of just the enormity of the amount of information that we exchange using emails. What other technology can we have to ensure that these documents are secure? Last week, on the question of online platforms and accessibility by Wanjiko, at least speaking for the Supreme Court, one of the more public interest related cases we had last week was Mitubel versus KPA, the question of evictions from slums. And I recall, because I didn't sit in it, but I recall that the registrar had opened the platform, the link for people who had an interest in the case. And I know that some of the organizations that are interested in evictions were allowed into the hearing through the link. I think that's an issue that I can raise to my colleagues, the Chief Justice and the Deputy, so that we make it firmer and more well known to parties that in cases where they have an interest, they can be brought on board. I think the other issue that I would like to speak to is the question of transcription of proceedings, at least speaking for the Supreme Court. I know that for the period that we were not able to be in the office, all our secretaries were allocated files to do transcription of proceedings, so that I think the very emotional, with respect, question by someone that judges are not working, clerks are not working, secretaries are not working, do they have consciences to receive pay without work? It's not true. So that I know for a fact that at least for the Supreme Court, all our secretaries have laptops and are able to work from home because we transcribe we record our proceedings. They are transcribing into the written form, so they're not idle even as they are sitting at home. That also goes for the question whether we're just idle and sitting and wasting time. I don't think that's true. On the Judiciary Twitter handle, we have bases. Sent out information as to which courts are doing what. So that this morning, every Thursday, every Friday, the Court of Appeal, for example, releases 30, 40 judgments. When were those judgments written? They were written during this period. Rulings are coming out from other courts. They're being churned out. So I don't think it's fair to say that judges are sitting and idling and earning their pay for no reason. At least I can speak for myself. I have not been idling, and my judgments are being written. My rulings are being written as late as this morning. So I think it's unfair to lump us all into a bunch of lazy bones who are eating public money without having to work for it. Lastly, I think my brother Richard Onsongo has raised fundamental questions. Are we doing all this to avoid or reduce deaths? Do we have advice from experts? What are we doing? I think precisely that is the reason why, for example, we have this webinar. We are asking these questions because not one lawyer I know, even Professor Kiama, who has a medical degree, can tell us where this disease is going. Fact, it's going to be with us for a while. And I think the conversation we are having internally in courts and with you, the LSK, is what do we do to reduce and avoid deaths? Because yes, people may die, but you don't have to die by walking into death. I think the question is, how do we avoid it, even as we know some may die? I think Jackie Manani's question was the more fundamental question for me. If we have advice that the courts are not ready to reopen for physical appearances from experts, why should we take it? That because we feel we must be in courts, let us ignore the experts, let us go to court and die because we must die. I think let us be logical about this, let us be reasonable, and then the ultimate goal should be the safety of all court users, including judges and magistrates. I thank you all for the opportunity, and I'm very excited to have been invited to participate in this meeting. Thank you.
Okay. Thank you very much, Justice Lenola, for the responses. Dr. Mercy Deche, there are several questions that are directed at you, and there are those that Linda will be able to share with you. One of them is on the issue of transcribing. Justice Lenola has given feedback on the Supreme Court. So how about the other courts? Is it something that the judiciary will take it up moving forward, or it will end after COVID, which we don't even know when it will end? And then the other one is on the participation of prisoners in the entire processes that the judiciary is coming up with. There is a lot of backlog, and mainly after the Muruatetu's ruling, some of the revisions are pending. So Linda, maybe you could also give a summary, and there are those that have not been able to summarize now, but I noticed that you are taking notes. So kindly, Commissioner Deche, kindly proceed.
Commissioner, you could also conclude by letting us know your electorate is curious about your role in the reopening of courts, as we are looking to blame judiciary As you're the female representative to the JSC, we're curious on your achievements during this time. Some people who want the courts reopened may be feeling that you have not done enough, like go to the streets to ensure that the courts are open. So you can close with that.
Thank you very much, Linda and Jackie. I hope I was asked so many questions and I can see many more on the chat, but I'll just try to answer those that I can, and Judge Lenola has already assisted in some. There's the issue of how do you ensure that the links are shared by the judges, like the judges do not withhold some of the links that they are supposed to be sharing for one reason or the other. This one is related to many other questions, some other questions that have been asked here. And if there was a time that the role of CUCs and bar bench were really critical, it is now. Because what I see, where we are at and where we are going to remain for a while, and even maybe going on forward, we will have to have a very close working relationship between the bar and the bench, such that so that those teething problems and those fears and anxieties that we may be having can be picked. And but that's what I can say about that. Ensuring, because right now we normally see how it is. Oh, so and so send me a link for this court, so that as we continue engaging, we can come up with ways in which to ensure that those safeguards are in place. That's what I would have to say about that, and re-emphasize and keep re-emphasizing the role of the LSK in the bar bench and even in the CUC in making sure that those things that we may not have anticipated do not crop up, and if they crop up, how we manage them. There's the issue of, although this was not a question, about other service providers open, the judiciary is still, has remained closed. I have also asked myself that, you know, when people talk of supermarkets were always opened, why is the judiciary always closed? And I came to see that the decision to, and the judiciary is not closed, by the way, it is just about downscaling. The decision to downscale was not so much meant to have people Skype work as to, it was just informed by safety concerns. And I have always thought that the courts, our courts are places of congregation where people do not just walk in and go out. A normal court is where people sit for an hour or two on benches that are squeezed. And that therefore is the difference between those other service providers and the court, and in fact, even including parliament. But having said that, the upscaling will still go on. But we have to bear in mind the uniqueness of our courts, and knowing also that in those courts we have people of a particular vulnerability, like people who are behind bars in custody, and what it would mean if they went there. And allow me to say this further, and I've already said that I am pro upscaling, but remember there is an institution that was found to have been, they're using the term epicenter for COVID. There's an institution, I'm not going to name any, where the workers were really, or the employees really tested positive. And I was thinking, if this was found to be the case in judiciary, and now the knock-off effect would have been serious. That is why at times it is good to maybe understand where some of these decisions are coming from. There is a other question of judiciary, that was Katisia, suggesting that judiciary needs to reach out to stakeholders to build capacity. This is especially for people, the Wanjikos. And I agree, this is important. And I had mentioned in my quick presentation that the Court of Appeal has started that initiative, and the High Court is taking it up. And I was talking to the Registrar of High Courts, Omange, this morning, and she was telling me that they are thinking also of doing what KRA did, you know, there are other services that Wanjiko accesses online, and they do not complain. Somehow they manage to access them, like KRA, getting pins and all that. And what KRA, I'm told, did was to train people in the cybers to enhance, to enable them now assist those who are not able to access their services online. So there is also that thinking of, if we worked with people in the cybers, how would it go? Or we will also be creating another level of cartels. But these are things that need to be discussed. But I agree with you that the judiciary needs to reach out to stakeholders. And you see, this kind of conversation is part of that stakeholder engagement. And I believe it should be sustained. With the issue of transcription, it was going on even before COVID, not just in the Supreme Court, but other courts. I know that UNODC has been supporting that initiative, both the transcription and the integrated systems, the one Beneka is talking about. And someone was, I've read a comment where someone is saying that judges should be released or excused from admin work, like these issues of ICT, and concentrate on justice. And contrary to that, what has been happening is that judicial officers, judges and magistrates are right at the center of procuring these ICT equipment and services, because the false starts, and Judge Lenola was in JSC before that, he would vouch for me that it was very procurement based, such that there were gadgets that were procured that were not of much use to the users. So what we are looking at is having a user-based. So even this transcription equipment and the integrated system is being procured with the users at the very core of it, so that we do not get obsolete equipment. There is this e-education of both the bench and the bar. Yes, it's true, this is critical. I know some bar benches have been having joint trainings or joint meetings. Mombasa had one this week, and before that, there was another one with the ICT personnel of the judiciary, just to be able to assist each other. And this again should be ongoing, and it should be very intentional and mainstreamed, so that it's not a one-off thing. It will be useful training. Wanjiko, I need to be honest and say that yes, there is a need to train Wanjiko. I just don't know how. Again, this is how stakeholder engagement comes in. There is the question of the self-rep clients in custody and how they access CUC meetings. When I look at the composition of CUCs, I think the people who attend are mainly the prison ward, the prisons department itself. And I think what the law had in mind to represent the interests of those behind bars, we have several NGOs that sit in the CUCs, like Kituo, like FIDA, and I believe those, the interests of these people, and there's another one which is which is very much involved in prisons. They sit in these CUCs. Yes, yeah, I was thinking of Jedida's initiative. Yes, that one. They sit there, and I believe their concerns can easily be represented. Jackie, I am horrified. I am horrified about that open air session. And again, I go back to personal initiative, the differentiation between how someone perceives their work or doesn't perceive their work. I don't know where that happened. But of course, that is now something when such issues are picked up and addressed. I remember last week, a senior lawyer called me and told me, I am very annoyed. I'm just from XY court somewhere in Central. And the way we were sitting there, I even feel as if I'm sick. I will never go back there again. And it was picked very fast. And the officer was reminded that it's not only in their interest, but in the interest of everyone to observe that So that is a challenge we anticipate, and we are going to have to deal with them. The reason why the defilement case was going on is because it's one of those that have been pinpointed that when during the plea taking, so as to release the primary victim, the evidence of the primary victim is taken at that particular time. But now that there is that problem that has been identified, I think we'll find a way of addressing it. I have talked about
there's a problem with your
and
audio.
integration. The issue, am I back?
Yes, yes, yes. No, it's okay.
Yes, I'm using my bundles, and when someone tries to call me, then there's that interruption. There's the issue of Richard Onsongo asked, and judge tried to answer. What are we trying to do? Are we trying to avoid deaths? Nobody can avoid death or infection. And I go back to what I said at the beginning. We are dealing with a barrier that no one knows, not even that head of WHO. He doesn't know, not even Trump. He will say this thing today and another thing tomorrow. At times we think Magufuli is right. Other times we think he's not right. So we are, as it were, in the woods. And the best that we can, it is better to have been so wrong, overprotective, as to have been careless. That's what I can say, because it is better to say that we treated it too abnormally, then it didn't treat us normally. Instead of saying we treated it too normally and then we suffered. So we are in a place, and there is no expert that we can really think of. The judiciary doesn't have experts, medical experts. The experts that the judiciary relies on are those of MOH. After all, we are in the same government. So we go by the MOH guidelines that we believe trickle down from WHO. There's a last question that I have tried to skirt over that Linda asked. You know, Linda, you and your heavy technology about vendor locking and all these big things. I will not pretend to know what exactly you're talking about, but we can have a chat on that concern on the side. Of course, having gotten the proper information from the ICT acting director, but the concern about procurement from the ICT ministry. Now, this was not a procurement. You're asking, was LSK concerned? The partnership with the ICT ministry was to somehow now overcome that barrier that is there when it comes to procurement. You know, procurement of ICT services and other services, when you need to get something very urgently, yeah, and the process is very long. Whether it is hiring these people, you can imagine by the time you shortlist and then hire, or getting all these licenses, you know, you cannot directly procure. Otherwise, someone can find themselves in court one on a Friday, or arrested on a Friday. So that was to avoid that. So that is why it was seen, it was better. And of course, again, there is no money. You know, procurement is when you're paying for something. This is assistance that we are getting from the ICT ministry. And I believe it is welcome for now. But like I said, there is the server that has been procured now. And I believe the storage, I don't know whether it's the same thing, server storage, because the concern was the judiciary did not have that storage, and there were concerns about the cloud, but now it has been procured, and I believe with that, the concerns over safety are being are going to minimize. And to say this again, the other reason why we have problems with connectivity is because, again, we had to resort to telecom, and telecom is very poor in some areas, especially around Migori. There have been problems in Migori and around that area. But again, now judiciary, government to government procurement is normally easier. But I believe in the new financial year, we shall be able now to move away from being stuck with one provider, because we will have the time to do the procurement. I hope I have answered all the questions.
Okay, thank you very much, Commissioner, for your responses. If anyone has a question, we can. You want to say something?
Okay, sorry, yes.
Remark that you made?
Sorry, you're on mute, Dr. Almasi. You can proceed.
I'm unmuted now.
No,
you
you can
said
speak.
something about the role of JSC, myself as a JSC commissioner in upscaling.
Yes.
I don't know whether, but because I was not seen in the streets. What we have been doing is liaising, working very closely with the leadership, the president and the convener of the branch chairs. So before and after their meetings with the CJ or before our JSC meeting, we work very closely. And that is why you find that we are on the same page as far as upscaling is concerned. But I hope that we are not going to have to reach a place where we go to the streets. Thank you very much.
Okay.
Thank you so much, Commissioner Deche. So, Senior Charles Kanjama, do you have anything to say? And when you're doing that, there is a question about EADR. What is the future of EADR as Justice Lenola rightly put it? EADR, very interesting name.
Okay, so I have several responses. I could start with the one on EADR. I think it would be fantastic if we expand the scope of alternative dispute resolution. The potential for alternative dispute resolution is tremendously broad, and we have barely scratched the surface. And ADR is going to be very useful in assisting the courts to reduce the backlog. And of course, ADR, because it involves less formal measures, there is a lot of room for innovation. And so I do agree that there is a room for ADR being done using electronic or digital means. It has personally been my dream for more than 5 years to even have an ADR center that handles disputes, both informal and formal disputes through digital and accelerated processes. There was a question, Jacqueline, about open justice for non-lawyers. There is even an organization, I think, in the United Kingdom called Open Justice. And open justice has been an issue that has been recognized world over with digital proceedings. Because when the courts exist physically, you can walk into the court, even if you're not a lawyer, and listen in. But what happens with digital processes? When digital processes are set up at the beginning, only the parties and maybe even only the lawyers are sent the links to log in and participate in the court session. And we even are reminded by the judicial staff that once your case is finished, please log off so that other lawyers who are on the queue can log in. So definitely, if the infrastructure for digital court processes does not allow as many people as would like to log in, whether they are parties in the case or not, to follow proceedings, including the media in particular and civil society, then there is a problem, because the Constitution of Kenya, and actually it is a standard principle world over, recognizes that justice should be open and public, apart from the special cases like cases involving children. So that is an issue that I think will need to be addressed more in the coming days. There was a question about whether the courts might be closed for 2 years. And we actually became concerned as stakeholders of the justice system when we realized that this coronavirus will not be defeated as quickly as we initially thought. And so we have to do a balancing measure between ensuring life goes on, ensuring access to justice continues, and on the other hand, ensuring there is health and safety. And that balancing measure is where the calibration of what point in the scale we should balance at is where there's been a bit of disagreement between different actors in the justice sector. But I would like to agree with what Bush, Advocate Onsongo, said, that the objective cannot be that we want to avoid 100% of deaths, because to avoid 100% of deaths, we may have to close for 2 years, and we will cause deaths in other things. People will die when they don't have access to justice. So I think the objective has to be to minimize deaths. And there's a big danger of anecdote-driven decisions. Allow me to explain, Jacqueline, that there's a difference between evidence-driven decisions and anecdote-driven decisions. So on social media, you hear stories, even in the traditional media, that this court proceeding happened, a judge died because of coronavirus, and this other thing happened, somebody died in a supermarket. If we follow anecdote-driven decision-making process, we'll never open the courts. So I think what counts is evidence-driven. What are the rates of infection? What is the transmission curve? What is the risk? And what measures can we put in place to minimize the risk? And that is what, as representatives of the Law Society, we have been trying to push for. There was a question that was asked by Linda Bonyo about whether the judiciary should be tech agnostic or not. And my thinking is that as far as possible, where we are talking about vendor-driven solutions, the judiciary should try to be technology agnostic, which means if one judge wants to use Zoom and it is widely available, another court wants to use Teams, another one wants to use Skype, why not? I have personally used all three of those platforms in different courts. In the Court of Appeal, I think I was on Skype, no, Zoom. In the Supreme Court, I was on Teams. In the High Court, I've been on Skype. So I don't see why we have to lock into one particular technology solution. I do understand the concerns about security, but I think all these solutions I'm talking about are improving their security week by week, including Zoom, which was initially having challenges of security. Let me also say, just to clarify, because someone asked the question, in the development of the case filing platform of the judiciary, which has been going on for the last 2 years, the judiciary decided not to use a vendor-driven solution. There was, for example, a very nice solution by Microsoft called CaseLines, but it was extremely expensive. And the license that had to be acquired annually would be in the hundreds of millions of Kenya shillings. So what the judiciary has done with support from ICTA, I'm saying this not as a member of the judiciary, but as a stakeholder who's participated in the process, is they got IDLO to support them so that they could develop their own solution, which will be 100% Kenyan owned. The same thing that has happened with eCitizen and with other important platforms that the government is using. So the government has learned from the dangers of buying off-the-shelf software that becomes very expensive. That also deals with the question of avoiding vendor lock-in. Jacqueline Manani said that social distancing in courts, in some courts, is failing. It is a mirage. And I think the solution is not to completely avoid social distancing, but to make efforts. We will make some failures in the same way that there have been some failings with digital use of technology, but despite that, we still need to upscale with some limited physical attendances so that court hearings can resume. Maria Mbeneka asked about transcription of court proceedings. I think both of us have been in LSK and very involved in trying to get digitization to move faster. And the judiciary had been choosing between the option of transcription and of course the one of stenographers, and they ended up choosing transcription. I do know, because I've heard this from several stakeholders in the judiciary, that they have plans to recruit a large number of stenographers, of transcribers, or people who can assist in transcription. And this is meant to assist the process. Again, there has been debate as to whether transcription should be outsourced or the capacity should be built internally. And I hope that that can help to deal with the court proceedings that are always too late. Finally, Jacqueline, let me deal with a question that was asked.
Yeah, just a minute. We have 3 minutes before we log off. So just we are giving you a half a minute if you don't mind.
Yes, yes. Advocate Gatobu asked, what measures can the court administration take to resume court fully? And I think I already inferred to the fact that we'd like more engagement with stakeholders like LSK and the court users committees, and would like parties to be given options so that the advocates or the parties in court are given options on whether they want to do digital proceedings or physical proceedings. So there are a number of mechanisms that have been suggested that if they are put in place, the court should begin by getting the cause list up and running in all the courts, and then dealing with the cause list that was suspended from 16th of March until today, which is slightly over 2 months. That's all, Jacqueline.
Thank you so much, Charles Kanjama, for the feedback that we have received. Would I want to hear from former President Mwamu to just summarize what we have heard of today, and thereafter Linda Bonyo will say something about the Lawyers Hub, and the closing remarks will be made by our able chair lady, Joan Neto. So, Senior Mwamu, kindly say something.
I really don't have much to say. I just want to thank Justice Isaac Lenola. I want to thank Commissioner Mercy Deche and my learned brother Charles Kanjama. I think you have done very well. You have acquainted yourself with the topic. And I think that lawyers who are pro and against opening up now have to grapple with the issue of balancing. As Justice Lenola observed that a number of judges in the Supreme Court are over 60. I think we have quite a number also in the Court of Appeal, and we cannot just ride roughshod over their concerns about health. And I think he has answered the question raised by my learned friend Richard Onsongo, that why are we fearing death? But we should also not run into death with into the hands of death with open eyes. So thank you very much, and also the people who logged in and have participated, the people who have sent questions. It has been a good thing, and we will continue having this conversation. And from the experts, I listened to the experts from the US and the UK. So we may just have to learn to live with this new normal. With that, thank you very much, and God bless you. Have a good evening.
Thank you so much, Mr. Mwamu. Linda, you could kindly share with the panelists, especially, not the panelists, the participants, especially the lawyers, on CPD and any future programs you intend to hold for lawyers. This is your moment.
Okay. So this is my moment to shine. I want to thank you all for joining this webinar. The Lawyers Hub, as I had mentioned, is all about law and technology, and we have been running trainings. We have held several CPDs this year and are accredited by the Law Society to offer CPD. So if you're here from the beginning to the end and you're interested in the CPD points, I think through Jacqueline, you get in touch. We do not charge for the CPD. We'll just pay the administrative fee to the Law Society that we pay. And so if you're interested in the CPD points, please indicate on the chat. We'll also give you an email. If you send an email to trainings@lawyershub.ke, if you send that email, you'll be able to get any sort of information around the CPD point as well. But I'd want to point you to our resources that we have. If you can go to YouTube, look for Lawyers Hub Kenya. We have videos on everything that you would want to know about law and technology. Our previous webinars also are posted on that particular channel. So you can watch it rather than binge watch something on Netflix. You can go on our channel and you can subscribe as well, so that every time we go live or we have new content, then you're able to learn from that. We're also really keen on tech policy, and so we engage on issues around affordability of internet. We've had challenges of people connecting, people going to school. We have challenges around privacy and data protection. So we are very keen on that and ask you that if you want to join that particular conversation that we hold, you can go to lawyershub.org. And if you go under member, you can become a member of the Lawyers Hub. It will take you 2 minutes to join our community of members and engage with us. I want to just thank you, Kisumu chapter of the Law Society, for doing this with us. We are grateful and are happy to host these discussions. And I want to also just reach out to the judiciary as well. There's so much out there. There's resources. We have actually been planning to do a hackathon to just see how we can solve the issues around payments. The people are having issues around filing online. Payments are taking issues. There are no integrations that are really working for everyone else. We have a really rich tech community that we work with that I think you could benefit from. We should continue this particular discussion in short. But I want to thank you all and also to ask you on the Q&A section, if you could just drop an idea, because I think sometimes people are in power, but there's no time to reflect and look for solutions. So if you have any idea on how we can improve this particular process, especially in digitizing the judiciary and getting lawyers on board and also training lawyers, please just go in the Q&A section and say, I think this is my idea. Somebody had indicated that we need an innovation strategic team working with the judiciary, that we go beyond the CUCs and look at the in-house counsel that are working with Safaricom. Some are working with, Telcom and all these big telco companies. Can we tap into the experience that they have and move from just the usual traditional ways of engaging the judiciary in this particular manner? So I think those are the few remarks from the Lawyers Hub. Thank you for joining us. We are live on Facebook. And so you can go to Facebook and share the particular post. You can go to Lawyers Hub Kenya and share the post. You can even host a watch party on your page so that people can watch, the video that we had streamed earlier. But I just want to say thank you, and that is it from us at the Lawyers Hub. Jackie.
Okay, thank you so much, Linda and the Lawyers Hub, for the good work that you do. I've seen a number of members asking for information about how to pay for the CPD. I would kindly request that the Lawyers Hub post the M-Pesa details. The payment is 1,000 shillings. There is a M-Pesa pay bill number, and you will have to put your P1 or PIT number as the account name. We kindly request that you give the details there on the main chat. As a moderator, together with my co-moderator, Byron, I wish to thank the panelists for a very rich and informative session. The questions that came from participants were healthy, and I'm looking forward to engage with you further. As I drop the mic, as Obama would say, because after our chairperson speaks, I'll not be able to say anything. For me, my parting shot is that any decision we make or any action we take, regard must be put towards administration of justice. And I thank you all. I wish to invite our able chairperson, Joan Neto, to give her closing remarks. Thank you so much.
This has been a very insightful discussion, and as a chapter, LSK Kisumu chapter, we are...
Okay, then you can speak a little bit so that we can hear you.
Can you hear me?
Yes.
Yeah, I'm saying this has been very insightful discussion, and as a chapter, we are very grateful that we have been able to achieve the purpose of this meeting. We thought it wise because at some point when there was a lockdown, the first week was okay. The second, third week, you could see people a bit crampy and the responses on various WhatsApp groups. And we realized that we needed to engage because, again, we get our daily bread from courts. So we thought it wise that we have a welfare subcommittee, the ones who have organized this. We are very grateful to them. And we also realize that when we engage, we begin to appreciate each other's point of view. For example, the lawyers were busy blaming, the lawyers at some point were blaming the judiciary, and the judiciary also had their own, challenges. And like they say, COVID is something that no one anticipated. So when we have these discussions, and from the comments, we are really grateful that lawyers are appreciating that this is very insightful, and we begin to understand why the judiciary is doing some things and why they cannot do some things. And this is really what we wanted. And slowly and slowly, I'm sure right now, Dr. Masindeche, we are grateful that the judiciary is beginning to think about opening up courts. And also as advocates, maybe we need to understand that as they also think about this, we still expect challenges. And as we continue engaging, we will be able to find solutions to those challenges. I was listening to a judge, a backbench discussion from Judicial Circuit Court, Florida. And the chief judge was telling the members of the bar that please understand judges, don't let it out on us. All of us are stressful, everyone is stressed. So I believe listening to Justice Lenola, that is the same thing he's trying to echo, that, we are working, try to understand us as we also understand you. We are all trying to do this towards a common good. So I want to appreciate the panelists. Thank you very much. As a chapter, we are very grateful that you found time and even heeded to our call to join into this discussion. I'm sure members of the public, our colleagues who listened in are very grateful that this is happening. And we hope to continue engaging more because this is the only way that we will find solutions to our problems during this time. And like Justice Lenola said, it is a concerted effort. All sectors, all stakeholders must be involved for us to achieve or overcome the situation we are in now. So mine is just to say thank you again to the Lawyers Hub. We are grateful. We are very, very grateful that you hosted us again. We hope to continue engaging as we find solutions on how to move forward. Thank you very much, everyone. May God bless all of us as we disperse. May we continue to be, patient, because again, all this, we have to be patient as we find solutions. So thank you very much. I really appreciate all of us. Charles Kanjama, thank you very much. We are grateful for your time. And all of us, really, the lawyers, I'm sure their magistrates probably are listening in because this is really for all of us. Thank you very much. God bless you. May God keep all of you. Jackie?
I was not supposed to speak after you're done. So Linda, we can leave or you can unmute all of us and we say bye-bye to each other.
Okay, before we say bye, thank you so much, Dr. And thanks to Byron as well. He was not able to stay on to the end because of the connection. But I'd want to also appreciate Lady Justice retired. Sorry, why did the name just disappear? Justice Alwatch, thank you so much for joining us as well and for your comments. We thank you for joining us. We're just going to let you share your ideas with us on the Zoom chat. So we'll stop the Facebook live feed, but we'd urge you to comment on the Q&A chat or the participants chat so that we'll be able to get solutions towards the question that we've talked about, so that it's not a talk shop, but we give actually alternative ideas to the justice sectors that are within this particular place. That said, I want to just say thank you and bye. There's a global bye that is done at Zoom chats where people keep saying bye until it goes off.
Yeah, that is what we want to do. Unmute all of us.
Okay, a video will play after we are done, just to about the Africa Law Tech Festival as we close. But if you would like to be part of the Africa Law Tech weekly news and opportunities that we send out on calls for articles, calls for consultation, we've seen on the WhatsApp, people are complaining that they have no jobs. And so we are looking at opportunities for lawyers that you can engage in joint consultancies and writing. So you can also you just send an email to info@lawyershub.ke and we'll be able to add you to the mailing list. Can we now start saying bye and then play the video? Is that okay?
Yes.
Yeah.
Bye.
Bye.
Bye. Bye.
Bye.
Okay, bye. All right, bye again.
Thank you.